Okay, let's dive right into this explainer and look at how the proposed 2025 Amendment Bill fundamentally rewrites the rules for every single contract you sign in Kenya. I mean, we're looking at a massive, ground-up transformation in exactly how agreements are negotiated, signed, and legally enforced across the whole country.
So this tangible piece of legislation, which was sponsored by Wajir East MP Adan Dowdy Mohammed, is essentially about shifting the balance of power away from large corporations and putting it right back into the hands of everyday consumers. Looking at the official document for the bill, the explicit goal is to protect parties against unfair and unconscionable terms. And really, this is a direct response to a legal environment that has, well, historically favored whoever had the most bargaining power.
Here is our agenda for today. We'll cover the end of unfair contracts, redefining freedom of contract, the absolute ban on negligence, the new reasonableness test, empowering consumers, and finally, the ripple effects on businesses.
Section 1. The end of unfair contracts. Shifting the balance.
You know, we've all experienced the sheer frustration of those take-it-or-leave-it standard contracts, the ones absolutely stuffed with dense fine print. Well, the core objective of this bill is to protect disadvantaged parties by giving courts the actual power to strike out terms that are clearly one-sided, unfair, or just totally unconscionable. For years, businesses relied on standard boilerplate contracts where you basically just sign on the dotted line, right? You had no real power to negotiate. But now the law is stepping in to say, hey, just because a clause is buried in a document you signed, it doesn't automatically mean a business gets a free pass to exploit you. Courts are finally getting the teeth to intervene.
Section 2. Redefining freedom of contract. The old versus the new.
For decades under Chapter 23, Kenyan contract law strictly upheld English common law, meaning you were absolutely bound to whatever you signed. But this comparison brilliantly illustrates the paradigm shift here. We're moving from that strict idea of freedom of contract to a new legal reality of substantive fairness, where judges actually evaluate the real context of the agreement. Previously, under the old framework, courts would really only step in during exceptional circumstances, like fraud or duress. The assumption was just that both parties freely chose to allocate risk however they wanted. But the new law introduces a statutory fairness control mechanism. It openly acknowledges that, let's be real, true freedom of contract doesn't exist when one party is holding all the cards.
Before we get into the heavy hitters of this bill, let's formally define negligence exactly as it's introduced in the new Section 2A. As you can see, it focuses entirely on the failure to exercise reasonable care. By codifying this exact definition directly into the statute, the bill ensures there is zero ambiguity left. If a business or service provider fails to use reasonable skill and care, they are legally negligent, period. They can no longer hide behind vague legal jargon to excuse poor performance or, worse, dangerous practices. So, this brings us to the crucial point, this new standard of reasonableness. This means exclusion clauses will absolutely no longer be automatically enforced just because you quickly sign the paper. The courts will look back at the exact time the contract was made and ask a purely objective question. Was this specific term actually fair and reasonable given what both parties knew or at least should have known at the time? That contextual evaluation is a massive, massive departure from how things used to be done.
Section 3. Absolute ban on negligence. The heavy hitters.
Now, what's really fascinating here is how aggressively the bill addresses the most severe consequences of negligence. Looking at Section 3A, this is a completely non-negotiable rule. Any blanket exclusion clause that attempts to avoid liability for death caused by negligence is automatically void ab initio, void from the very beginning, with absolutely no exceptions. Let that sink in for a second. It literally doesn't matter if the contract is commercial or consumer-facing. If a term tries to claim a company isn't responsible if their lack of reasonable care kills someone, that term is legally erased. It is treated as if it was never even written.
Let's look at this matrix to really lock in how these different liabilities are treated now. Death and injury waivers? Completely banned. But property damage waivers? Those must now survive the strict scrutiny of a judge. This two-tiered approach is highly strategic. It unconditionally protects human life while also recognizing that, hey, in the real commercial world, limiting financial liability for property might sometimes make sense. But, and this is a big but, only if the business can prove to the court that the limitation was genuinely reasonable the moment the ink dried.
Section 4. The new reasonableness test. Context is everything.
Let's look at the more nuanced changes to see how this reasonableness test actually plays out in your daily life. What happens when a hospital admission form, or maybe a gym membership waiver, tries to deny all responsibility for your damaged property? Well, if a business tries to limit liability for property loss, simply signing the contract no longer means you voluntarily accepted all the risk. The court will objectively assess if that waiver was actually fair when you signed it. The burden entirely shifts to the hospital or the gym to justify exactly why their waiver deserves to be enforced under your specific circumstances. And here is a brilliant feature of the new legal framework. Instead of throwing out your entire agreement just because of one bad clause, judges now basically have a scalpel. They can surgically remove only the unfair limitation. So if a judge looks at your contract and finds a specific liability waiver unconscionable, they'll just strike that single part out. The rest of your contract, the actual gym membership, the hospital admission, the core service agreement, that whole shebang remains entirely intact and legally valid.
Section 5. Empowering the everyday consumer. Closing the loopholes.
Beyond just physical harm and property loss, Sections 3B and 3C introduce these sweeping, game-changing consumer safeguards. Businesses can no longer use sneaky boilerplate clauses to deliver terrible service or defective goods without facing total accountability. Think about it. Have you ever bought a product where the so-called guarantee actually ended up stripping away your basic consumer rights? This bill targets that exact loophole. A supplier cannot legally claim they're entitled to render no performance at all, or give you something substantially different than what was reasonably expected just because of some hidden clause.
You can actually see the real text right here from page 1208 of the Gazette Supplement. It explicitly states that guarantees absolutely cannot negate a consumer's expectation that goods will be fit for their intended purpose. This captures everything from formal manufacturer warranties all the way down to informal promises of satisfaction. If the goods turn out to be defective while you're using them, or if a loss happens because of negligence in manufacturing, any contractual attempt to sidestep liability is dead on arrival.
Section 6. Ripple effects on business. A call to action.
Now, while this David versus Goliath shift is a massive win for consumers, it creates immediate critical exposure for companies all across Kenya. Industries that historically relied super heavily on standard service-level agreements loaded with blanket negligence exclusions. Think construction, healthcare, transport and logistics, professional services, hospitality. They're going to face the most profound operational shocks. Because they can no longer contractually shield themselves from negligence suits with a simple boilerplate paragraph, their entire risk allocation model has basically been turned completely upside down. So if you're a business owner, listen up, because you need to take these 3 steps immediately. First, you have to scrub your standard terms of contract and remove any absolute bans on liability, specifically regarding death or injury, to align with the new reasonableness test. Second, you urgently need to call your insurance provider today and review your professional indemnity and public liability limits, because your legal exposure just skyrocketed. And third, don't assume your old contracts are safe. If you have existing long-term agreements with auto-renewal or variation clauses, this new legislation will likely apply the second that renewal trigger is pulled.
As we wrap up this explainer, I want you to ask yourself, how will this statutory shift toward true fairness change the very next standard contract you're handed to sign? We are witnessing a historic recalibration of Kenyan contract law right now, placing substantive fairness and the protection of the vulnerable way above strict, rigid adherence to outdated common law principles. The rules of the game have officially changed. Thanks for joining me on this deep dive.